Very good. Welcome, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our community conference call, which we hold every other Thursday. The provisioning of information is based upon the disclaimers you heard when you were logging in. We don't guarantee any of the information. We try our best and make sure you understand there is no attorney-client relationship just because we gave you some direction. With that said, let me note today's date. It is October 27th, 2022. I have a bunch of questions. Today, more than ordinarily, I think there's a bunch of questions that I consider to be frequently asked questions, which we will take first. They have been posted already on the forums. I'll take those first, followed by the regular questions, and then I'll do new questions. Today is a good day because the team, I had instructed them, as always, to stop taking questions after 12 or 13 questions. Last conference call we had 24 questions. That gives me no time to talk to people about new issues that come up. So today we should have plenty of time. No issue with that. Let me just make sure that everybody can hear me and we get started.
The conference is now in conversation mode.
We can hear you.
You can hear me fine? Very good. Thank you. Excellent.
Yeah.
Excellent. Excellent.
The conference is now in presentation mode.
So today I'll definitely have time to answer new questions. Let's begin with the first frequently asked question. And I hope all of you are soon in this situation where you're asking me the same question. What happens to H1B after green card approval? That's a good question. What happens to the H1B? Well, once you have a green card approval, the H1B is pretty much automatically terminated by operation of law. Now, the concern here of this community member who posted this was, most people I know did not have their H1B revoked after green card approval. So I'm a bit concerned. Their company lawyer had revoked the H1B, and the answer is there is absolutely no need to be concerned. This is by operation of law, but just to keep matters orderly, it's a good policy to send in a revocation notice, and that should not be of any concern to you. That has already happened anyway when the green card is approved. Okay. Is there any follow-up question on this issue? What happens to H1B after green card approval? Okay. Whenever you have a follow-up question, you can press *5 on your phone. If you have a follow-up question, you can press *5 on your phone. All right, let's go to the next frequently asked question. Now, this is another question that I'm asked quite a lot. So the question is, how am I eligible for OPT? Do I have to be in F1 status for 1 academic year? So there's some other questions after that. So what I did was I just put a quick response to this because this is asked so many times. And the response is that to be eligible to apply for OPT, you must have been in full-time student status for at least 1 academic year by the requested OPT start date. This is an important point to remember. So if you are requesting OPT 3 months from now, 3 months from now you must be in 1 year. You should have been in 1 year, 1 academic year. So it's not the same as calendar year. It's 1 academic year. So if your academic year is 2 semesters, then 2 semesters is what is needed. So you must have been in full-time status for at least 1 academic year by the requested OPT start date. You must be maintaining F1 status at the time of applying for OPT. So you can't convert to H4 and then say, I'm going to get my OPT. And the last is that you have not used OPT at the same degree level previously. This is, most of you already know that, but I'll repeat it. So what happens is, at each level of your education, bachelor's, master's, PhD, you get OPT again and again and again. But if you did a second master's and you already used your OPT, you won't get OPT again. OPT is only for the next higher level. And by the way, STEM OPT you can get for 2 programs, but after that you don't get STEM OPT. But post-completion practical training you can get for every program that you do at each successive level. *5, if you have a follow-up question on this, press *5. Okay, I'll cover the other questions they had also. So this is from area code 530. 530, where are you calling from?
Hi Rajiv ji, this is Amit. I'm calling from Atlanta.
Achha,
Yes,
very
my
good.
number is from California.
Very good. Let me finish.
Yes.
You are the one who posted. Let me finish your other questions. So 365 days is not needed. What you need is 1 academic year. 2, if we ever need to change to H4, can she travel to India, come back without F1 stamping? Yeah. If she already has an H4 stamping, she doesn't even have to go to India. All she has to do is drive to Canada or Mexico and return showing her H4 visa stamping. Okay. So that's not a problem at all. Doesn't have to go to India all the way.
Okay. So Rajiv ji, regarding the first point, the exact case is that my wife applied for MBA program in March, and we applied for her F1 change of status. She got her change of status in September this year, and now I'm expecting my PERM approval by November. Okay. So the DSO told that she has to be on F1 status for 365 days.
No.
Minimum to be eligible for OPT.
That's an incorrect articulation of the law. So what you do is just Google studyinthestates.gov. So I think the exact website is dhs.studyinthestates.gov. Go there and read the conditions for OPT, grant of OPT. You'll see it's clearly written there. And this website is government's website. So whatever is there is the force of law. Whatever the website says, that's the law. You can show it to your DSO.
Okay. So if she switch backs to H4 and then she switch backs to F1 in case any unforeseen thing happen, so she will still be able to get OPT even if she has been doing she has been in F1 status for 1 year.
No, because
and last status is F1.
Remember, she has to be maintaining F1 status when she applies for OPT.
Yes. So in case she converts to H4 and then converts to F1, and at the time of OPT application, she is on F1, will she be eligible?
Yeah, because if she has 1 academic year as F1, yes. You know what? I just thought of something. Hang on. Let me think about this for a moment. I remember there was a regulation that said you don't have to be in F1 status for 1 year. You have to be a full-time student for 1 year. Amit, do me a favor. Double check this point of law. All of a sudden I had a flashback. A few months ago, I had actually looked at the law, and my conclusion was you do not have to be in F1 status for 1 year. You actually have to be a full-time student for 1 year. And even if you were on H4, at the time when you applied for, that is, I think, the right law. At the time when you apply for OPT, you should be in student status. So that is the correct statement of law. I'll try to double check it. I can't guarantee it. We are pretty busy. Have this double checked. I just suddenly remembered, I had a flashback that this is what the law was. I always used to think that you have to be in student status for 1 year. No. You have to be a full-time student for 1 year. And when you apply for OPT, you should be in F1. I think that's the law.
Okay. So, and when she is on full-time student, she can be on F1 or H4, whatever it is.
No.
Right?
While she was a full-time student, yes. So let's say I went to school 9 months on H4 and then I got an F1. 3 months later, I can qualify because I have been a full-time student for 1 year. And at the time when I applied for my OPT, I was already on F1 status. That's the way I remember reading it. Okay?
Okay. Got it. Yeah. Thank you, Rajiv ji.
You're welcome. Good luck.
Yeah.
Okay, let's go on to the next frequently asked question. This is a very interesting issue. PERM issues for a green card for remote jobs, headquarters. So I'll tell you the history of this problem. Back, I think it was I want to try to remember when this started. I think I had been in practice about 7 years or 5 years. 1998, I think, is when this started. So what happened was, as the economy shifted to a service model, this became a common problem. There were a lot of consulting companies. So let's say that our company's employee, Tom, works in Atlanta, but he's there on a project. We might have to move him again at any time to California, Washington, D.C., New York, Illinois. We don't know. So if you consider, first of all, for green card job to be put through labor certification process, you have to have a permanent place of work. Now, he's in a temporary job, temporary project. His job is permanent, but his project is temporary. So what do we do in those cases? Because consulting employees can keep moving. So the Department of Labor said, in such cases, you can consider the principal place of business or the corporate headquarters to be the job location, even though the job is relocatable. So let's say for remote, this is a little different situation. I'll talk about it for a moment. So what we started doing, and we've been doing that for almost 30 years, 27, 28 years, what we do is, let's say that the employee is working in California temporarily. My headquarters is in New York. I will file the labor certification with the job location New York. And that way, if the employee keeps moving, we don't have to restart the labor cert. We don't have to restart the process. So that's the number one point. Jobs that are capable of relocation are filed through the corporate headquarters or the principal place of business, number one. Now, here is the problem with remote jobs. If a job is always going to be remote or remote is allowed, then the employer must advertise nationally, because then any US worker anywhere in the country can do that job. You have to do national advertising, and you have to clearly say that this job allows remote work. Those two things. Now let's look at the questions. I'm currently on H1B working remotely. So H1B criteria are different. For green card, things get really complicated. My H1B petition has two addresses: home, which is Virginia; office, which is Pennsylvania; the corporate headquarters is New Jersey. Employer filed a prevailing wage determination in March 2022. It got approved in October. They had to refile the prevailing wage in July. I came to know they did not mention the main headquarter address, which is New Jersey, and they put Pennsylvania address. They can also do that. That's a separate theory. But it makes me very uncomfortable. Why would they do that? Maybe it is because the salaries in Pennsylvania are lower. That's one way I could look at it. I don't know where the office is. But the problem is, you should not be doing that kind of forum shopping. That can cause a lot of problems for the company and for the lawyers who are doing it. So in my view, this job, if it is a remote job, should be advertised nationally, and you should put either the corporate headquarters or the principal place of business. One of the two. You should not put an office where you are not going to work. I think that's problematic. Let's just make sure, have a conversation with your lawyers, make sure that there's nothing inappropriate here. You're not doing it just because the salaries are lower. Because if you're just a one-person office with no accommodation for other people, it could be problematic for the employer and for the employee both. Press *5 if you have a follow-up question. Press *5. This one is area code 317. Area code 347. Where are you calling from? 347.
Hey Rajiv, this is Ravi. This is I posted this question. I'm in Virginia, but my number is from New York.
No problem. So go ahead, Ravi. What other questions do you have?
So my question was, they mentioned me. I already had a discussion with my attorney, and what they told me, because my green card application is for a remote job, they cannot have. Oh, before even I start that, so basically, I am working as a full-time employee for this company.
Right.
I'm not working as a contractor.
Right.
This is not a consulting job.
Right.
All of the offices, like Pennsylvania office and the New Jersey office, is the same company that I work for. So initially, when they filed my green card application, they put Pennsylvania office because my H1B is on Pennsylvania. And they did that. And then when it got approved, they say, okay, we have to change it because we cannot have other offices except the headquarters. So they have to have a headquarter office address in the green card application. So is that correct? I was kind of confused at that point because my H1B.
Yeah, it is potentially correct. I don't know your exact situation, but let's say that they have considerable business out of the Pennsylvania office, and that your supervisor is in the Pennsylvania office, and your work product goes to the Pennsylvania office. There are too many indications for me to give a blanket opinion.
Okay.
But if the work is going to the Pennsylvania office, that's, I think, appropriate. Okay.
No, it's not. It's just
yeah.
My boss is in Connecticut. My other colleagues is in a different location.
Yeah,
remote.
I'm a little uncomfortable with this. I would probably have some reservations filing this kind of a green card because I think this could be construed as trying to forum shop and artificially suppress the wages because New Jersey wages are much higher than Pennsylvania wages. Okay. So that's my only concern.
So it's okay, you said, that's fine.
No, I said I don't know.
Filing with the headquarter office?
No, I don't know.
Oh, okay, you don't.
Yeah,
okay.
If you file through New Jersey, it's obviously okay because the job is relocatable in the sense that you could relocate. So I don't know if Pennsylvania is an appropriate forum. There are too many facts that I do not know. And it's a legal decision your lawyers have to make. But, I don't think you should be affected by it unless there is any active fraud. But it's hard for me to make that judgment. Okay?
It just the reason for me to ask this question is I just want to double check because I know I already discussed with them. They have discussed with my HR and, we had a long discussion on that. They said, this is always in my favor that it should be on the headquarter office because if there is an audit in future, it will be difficult for them to justify.
Yeah, you can always play them a portion of this recording that we've talked about. I'm uncomfortable, but if the lawyers are justified in making that judgment call, I cannot second guess them because they have more facts than I do. I'm just making guesses. I'm telling you what the problems are.
Okay. So now, the second question that I have, my H1B application is also remote, and my H1B application has two addresses.
Yeah, that's all right.
One, my home address,
and
my office address is Pennsylvania because that's my Pennsylvania office is my
that's not an
location,
issue.
basically.
That's not an issue.
That's fine. Okay.
Yeah.
Okay. Okay. Sounds good. So, is there any way, because they filed my new prevailing wage, and it's taking so long, is there any way that prevailing wage can be amended or expedited?
No, you can't expedite or amend. No. Okay.
Oh, okay.
I gotta go.
Okay.
Good luck.
Okay, no worries. Thank you very much,
You're
Rajiv.
welcome.
Thank you. Thank you.
Bye-bye.
Bye-bye.
Yeah, remember we still have limited time. So, okay, let's go on to the next frequently asked question. I'm going to lock the conference. What time did we start? 12:30. I'll lock the conference in about 12 minutes. So we won't take any more callers just to make sure that we cover the people who are here. So here's another one. Can an H1 visa holder rent via Airbnb? Is this a violation of status? So I'm not going to answer the tax questions because that's not my area of practice. I don't know how the taxation would work. But again, because the government has given us so few bright line, clear rules, I can only make guesses. And my guess is even renting on Airbnb could be considered unauthorized employment. That's the way I see it. I would not take that chance if I were you. It is true that if employment is, or if your work is passive, you don't have to worry about violation of status. But passive income generation means something like buying stock in the stock market. If you buy stock and it's a long-term investment, you're not doing anything. You're just investing money and getting the returns. I think that's okay. What if you start day trading? That's a little bit more difficult to answer. So I really can't tell you that there is a clear, bright line guidance from the USCIS on this issue. I would avoid this unless you are the adventurous kind. Just remember one thing, and I've said this many times before. In unauthorized employment, the fact that you were engaged in unauthorized or questionable employment or income generation is less damaging to you than lying about it. So let's say you get caught and they say, well, you've done this wrong. I shouldn't say caught, but let's say government makes an objection against this activity. What can they do? They can ask you to go outside, get a visa stamp and come back. That's all it takes. Can visa be denied on these grounds? No. Can it be delayed? Sure. But it's not a ground to keep you outside the US that you worked without authorization. But if you lie about it, that is a permanent bar from entering the US. So be careful with that. Okay. I hope that was clear. Press *5 if you have a follow-up question. Press *5 on your telephone. This is from area code 508. 508, where are you calling from?
I'm calling from Denver, but my number is from Boston.
Oh, you guys are all over, man. Okay, so what's up?
So if I just don't do Airbnb, if I just do long-term rentals, is that fine, or is that more like comfortable for our status or my status?
No, I think it's still a problem because you are actively doing business even if it's long term. See, the difference between rentals and buying stock involves nothing but press of a button. Whereas when you rent, you have to actively be involved in leasing or management, etc. I think it's a violation, in my opinion.
Okay.
Okay.
Okay, thank you.
You're welcome. Good luck. By the way, I do keep track of these things, and if I find that there's a change in USCIS attitudes, I'll post that in my social media. Okay, I think there's another question. If it's a repeat question, I'm not going to answer it. Let me just double check. Area code 347, you have a repeat question? I already talked to you.
No. I have a question on this topic, the one that you were discussing.
Okay, yeah, go ahead. Go ahead.
So, how about just a rental, not Airbnb? If I have a property and I'm renting it.
Yeah, same problem.
Not Airbnb, like
Same problem.
Same problem.
Same problem. I think, see, the less active you are, the more argument you can have that I'm not engaged in unauthorized employment. Okay? The less involved you are. So think about going from investing in stock market to day trading to actually investing in, for example, a company that you also happen to now and then manage. So these are all increasingly more problematic areas. So from just owning your own house to renting a part of it out to going out and getting a rental property, I think they're all progressively more complicated issues. I think it would be a problem. That's my guess. Okay.
Is there a way to find out whether it's legal or not legal? Is there anybody that we can reach out to make this thing clear? I know this is a kind of gray area. So
no, USCIS does not give advisory opinions. They used to many years ago. They don't give advisory opinions. IRS gives advisory opinions. USCIS does not. Okay.
Yeah, but IRS doesn't know about the immigration.
Yeah, they don't know. That's true. Okay.
Okay.
Good luck.
Thank you.
You're welcome. Let's see. Another frequently asked question. Oh boy, we did have a lot of frequently asked questions today. So how long does it take from PERM to green card? So here the country of birth is United Arab Emirates. So maybe a couple of years normally. It can be a few months less or a few months more. There are many variables. But if you're India born, then 10 plus years, 8 plus 9 plus years, something like that. There is no difference between NIW and PERM for India born people. Time wise, it's about the same. But if you were born in any other country, NIW could be a lot quicker because you're not going through labor certification PERM process. You could be saving almost a year unless the NIW adjudication is very slow. You could be saving about a year in the PERM processing time. So NIW would be a lot quicker. Then the question is, how long does one have to wait if the company applied for PERM? I would say a couple of years is average. Can this be done on F1 OPT plus STEM? Yeah, it can be. When you still have STEM OPT left. So I have an article on this. If you just Google my name, Rajiv S. Khanna, Economic Times, you'll see my articles, and one of them deals with this. It's also in my blogs. Typically, my blogs have more information than the Economic Times articles. In this scenario, how would it work if the person also submits NIW? It would work just fine. Your lawyers can organize that. I don't see any problem with it. You can certainly do that. Okay. Star 5, if you have a follow-up question on this. Star 5. One thing though, be careful because when you file the NIW, you are making an argument about why you should not be made to file a labor cert, PERM application. Okay, so be careful. It can be managed, but it should be done carefully. All right. Let me go on to the next question. Here's another frequently asked question. So this one is applying for E2 visa with a pending family-based green card. So in my opinion, that can be done because E2 visa is kind of a dual intent visa. It allows you to have a green card pending as long as you have no intention to violate US immigration laws and you have intention to come back to your home country if required. I think you can get your E2 visa. We've had that happen before. And who can be the main applicant? Can the primary applicant on E2 be my wife, who is also the primary applicant on F3 immigration? Yeah, I think so. Do you recommend going through consular processing or adjustment of status for my wife? Okay, first of all, even though you are a Canadian citizen, E2 visas are an exception to the rule that Canadians don't need a visa. So if you got a change of status within the United States to E2, next time you travel, you'll have to go to a consulate to get visa stamping. So why do it twice? In my opinion, it makes sense to just do an E2 at the consulate. If on the other hand, there are some considerations because of which you are doing change of status, that's acceptable. So we just did a change of status for somebody to E2. They were here on H4 and they are close to getting their green card. So it didn't make sense to send them for visa stamping, especially during COVID delay times. Otherwise, I would just do visa stamping in Canada. It's not that long. It was taking a couple of weeks under COVID, maybe 6 weeks. So something to think about. Star 5, if you have a follow-up question on this, Star 5. All right. Oh, there is a follow-up question. This is from, let's see, area code. Oh, you're calling from British Columbia, right? 778?
Yes, we are in Vancouver.
Yes, ma'am.
Hello, Rajiv ji. So we are intending to do the adjustment of status over consular processing because of my pending immigration that I have.
Okay.
Is there a possibility of refusal? Is there more chances of refusal in adjustment of status compared to
Okay.
consular processing?
Let me just make it clear. So technically, when you are in non-immigrant side of things, you call it change of status. When you go to green card, you call it adjustment of status. So I think what you're saying is, I want to change status within the United States, right?
Yes.
Yeah. So yeah, I don't think so. I don't think there's any larger chances of denial. No, ma'am, not at all.
Okay.
Okay.
Okay. So, and if we are there for 3 months, because I know there is a 90-day thing. So if we are there on a H1B on a visit and be there for 3 months, and after that, we find a business and apply for E2, is that okay? Or
I am concerned about those cases because if it is a preconceived intention to find a business and apply for E2, even if you do it 5 months after you enter, government can create a problem for you. So you should not have, at the port of entry, you should not have the intention to change to E2.
okay, so how do we do change of status if we have to do?
I would not, if you have zero intention of doing it, you are coming to explore the business and you have the intention to apply for E2, and somehow later on your intention changes, that's okay. But it's got to be done truthfully. Can't play games with the government. Okay.
Okay.
Good luck to you.
Okay. Thank you.
You're welcome.
Thank you.
You're welcome. Okay, let me lock the conference because we don't want any more than what we have people here already.
The conference is now locked.
Excellent. Now, I think our frequently asked questions are finished. Let's go back to regular questions. So this was a frequently asked question we answered. Rishi says, who can authorize CPT during winter break? Your DSO. It's allowed. Winter break, summer break, they can do CPT. Yeah. They should be able to do CPT. What they can do? If they have any questions, they can call SEVIP and in ICE. SEVIP should be able to answer this question for them. I don't see any problem with it. *5 if you have a follow-up question on this. Press *5 if you have a follow-up question. Okay, that one is done. Let's see. If your I-94 is not found online, are you on the call who posted this question? Mohan, are you here? Okay. My kid came with me first time to USA. I-94 was not found. I visited CBP officer. He's not ready to listen. He did not fix my kid's I-94. Also, he removed my current I-94 online. Travel history section looks good with recent travel. Do I have any issue with my current extension? Well, first of all, I'm not sure what is going on. They shouldn't be doing all this nonsense. This needs to be addressed by your lawyers. They should get in touch with CBP. I can't predict what can happen with extension. Looks okay to me. Will there be any issue on next stamping or traveling? I cannot predict that. Can I have issues with my green card? Again, I don't know what the problem is. No, don't go yourself to the CBP. Have your lawyers call them. Okay? Have your lawyers communicate with them. That is what I would recommend. *5 if you have a follow-up question. Yeah, I like some kind of a written record in these cases. So tomorrow if I end up in court, I have something to show to the judge. Next question is working remotely from another country. So first of all, I have written an article on this. While you're an H1B, you can work from other countries. There's no limit on it. Just Google my name, Rajiv S. Khanna, The Economic Times, and you'll see I have a full article on it. On immigration.com, in the blogs, we should have the same article with a little more information. How long can I work remotely? There is really no time limit. You can use the old employer's H1B stamp for the new job. Double check with your lawyers if there is any other issue. But yeah, you can use the stamp interchangeably with new employers. Parents got their visitor visa approved in DS 160. You thought they were going to stay for 1 month, now you want them to stay for 4 months. So typically this may not even be an issue. When they land, they'll be given 6 months. Normally that's the standard for tourist visa cases. I don't see it as a problem. I've read online that if my company applies for a green card, I-140, I can leave USA for few years and come back again. This is in our frequently asked questions. This we have talked about many times. So please go to immigration.com and read the frequently asked questions. Theoretically, this is possible. Also, you will be cap exempt if you just take the remaining time on your H1B. Just you can Google H1B remainder option. So that should cover you. But this is all covered in our frequently asked questions. *5 if you have a follow-up question. Press *5. Okay, let's go on to the next question. And this is, I can't read the question number. Question number 8. Okay. On H1B status, pending I-485, 765, I-131, based upon an approved 526. So it's an investor visa. Okay. And no H1B visa on the passport. Traveling back to the US, I'm very uncomfortable letting people travel like that. Because if your H1B is denied, you also lose your 485. You would have to convert your case to consular processing and be going through consular processing. Or come back on H1B somehow and then refile. Also, if you leave while I-131 is pending, you'll have to refile it when you return. So I think you should wait until you get your advance parole. Yeah, I'm very uncomfortable letting people travel like that. And I don't think you have to wait. If somebody lands on H4, they can apply for a 485, in my opinion, the very next day if they want. I don't see any problem with that. *5 if you have a follow-up question on this. Okay. A and B and B, all this we covered. Next question is question number 11. Switching from H1B to H4 EAD without a gap in the ability to work continuously. I don't know of any way to guarantee that. The big fly in the ointment is the time it takes to process the H4 EAD. It is so difficult to predict that. Yeah, so I'm not sure I can give you any good advice on that. Sorry. And then H1B to marriage-based green card. Spouse does not have a job. I'm on H1B. Should I apply for marriage-based change of status? Yes, talk to a lawyer, because you can count your own assets in ability to affidavit of support. That's possible, and you can also get a joint sponsor for the affidavit of support. Anybody who's a U.S. green card holder or citizen can co-sponsor you with your wife. I don't know if you're a husband or a wife. Yeah, so your spouse can be one sponsor for the 864 affidavit of support, and anybody who's a green card holder or U.S. citizen can be a joint sponsor. It doesn't have to be related to you or a friend. Anybody who's on your side can do that. *5 if you have a follow-up question. *5. Okay. So the next question, and this is the last question, then we'll take new questions if any. Happy Diwali to you as well. I have 2 approved I-140s from 2 past employers, A and B. Joint company C. They delayed 485 filing. We are waiting for PERM. Filed H1B extension request, got RFE that says, because why didn't you file the 485? So the answer is because I'm not working with those employers. So you should be able to get an extension. If you are not working for those employers, A and B, how can you file 485? So we have received extensions on those bases. I don't know who's advising you, but that's what you should have done. You should have explained that situation. So I don't know, the rest of the questions are kind of so unnecessary, and I'm not sure I can answer them. I would never have put you on B2. With B2 pending, you cannot change to H1. You have to go outside USA. Yeah. So I'm not sure what to tell you. I hope this is your question. Area code 571, this is your question?
Yes, Rajivji. Namaste.
Okay, so I'm not sure who gave you this advice.
Yes.
You could have easily gotten an H1B extension.
Right now it got denied.
So did they explain how can I file a 485 when I'm not with those employers? Obviously not.
I've not looked at they have not shared the RFE response, so I have no idea.
Okay.
And it got denied on October 20th. And since my H1 was expiring on October 13th and I-94 on October 23rd, so they suggested me to go for the B2.
If I were you, I would file a lawsuit
What?
against that denial. That's what makes the most sense to me.
Okay.
Okay, because this is an incorrect decision. And by the way, if the lawyers have not adequately briefed this issue, they should file a motion to reopen and brief this issue, so that when it goes to court, the file is complete. Okay?
Okay. But in the meantime, can I work?
No, you cannot.
Okay. So what are my options? Like
You
can we
file
go through the question?
a lawsuit. You ask for a stay of that denial decision. If the court stays that decision, you can go back to working, most likely. Check with your lawyers. I don't know how the H-1B extension was filed. But while the case is going on, you could be working. That's the only option I see for you.
What is it? Sorry,
File a lawsuit.
what is it? I cannot work. Mm-hmm.
You cannot work right now. But you file a lawsuit. In the lawsuit, ask for a stay of the denial. And if the denial is stayed, you can probably get back to working because your H-1B would still be pending then. Okay?
Okay. But
That's,
if I file a new petition with the same employer or different employer, will it make a difference?
see, I don't
Or-
know. I don't know what the ground of denial is. To me, this case should never have been denied. So I'm at a loss. I can't really give you any advice. Because in my view, this case should never have been denied. Why is it denied? It's an obvious approval case. देखो ना, if I don't have the job that
And-
sponsored me, how the hell can I file a 485? I cannot. Right?
Right. And what about if, since I have already applied the B2, so should I go for biometrics or delay it? Or And
I have
what are the chances
I have zero opinion about that. If you have filed it, follow it through, but I think lawsuit is your only option. Okay?
Okay.
Have that looked at.
All right.
Good luck.
Thank
You are welcome. Anyone has any question, press *5. Anyone has any question, press *5. Okay, excellent. We have only one question today. Excellent. 2. Okay, 2. No problem. Let's go in the order that you guys logged in. First one is from Florida. Oh, there's 3 questions. Okay, we'll go with Florida, then Virginia, and then Texas. Okay. So let's go to Florida first. Florida, go ahead. I can hear you.
Yeah, hi Rajivji. Good afternoon.
Good afternoon, sir.
This is Raghavendra,
Yes, sir.
and this question is regarding my 485 filing. Actually, my I-140 was approved in EB1C back in 2018 when I was on L1A visa,
Right.
and I moved back to India due to some personal reasons in 2018, and I came back with the same employer on L1B now, L1B visa in the last month. So I'm planning to file my I-485 under the EB1 category, whatever is pending. Is it fine to file the 485 which was approved underlying petition of I-140 in EB1C with L1B visa?
This is a complicated situation. I can tell you, I can't answer your question about your case, but I can take a couple of minutes and explain to you the problems and the concerns I have. First of all, L1B is not a path to EB1C. L1A is, but L1B is not. Okay. However, there are several positions which can qualify for both L1A and L1B. So I don't know what the position is.
Right.
If the offered position is such that it can qualify for both L1A and L1B, you are justified even in filing a new EB1C. Can you use that old EB1C I-140 only if the same job is still available? Okay. And only
Yes, I'm with the same employer.
Yeah, only if you still qualify for EB1C, the same job. If you still qualify and the job is still available, I see no problem. Fact that you are currently on L1B has little relevance, but like I said, I don't know the exact facts of your case. I have to look at the two jobs. Why an L1B was done instead of an an L1A, that makes no sense to me. So I'm very curious, why would they do an L1B? So I have to know what the differences are. But in principle, this is all possible, no problem. Okay?
Okay. And the 485J supplement, whatever submitted by the employer, it reflects the I-140 in EB1.
Okay. So that's irrelevant for our discussion right now. Our discussion is simply, can I file the 485 based upon the old EB1C? Theoretically, yes. Practically, I don't know. Okay?
Okay. So is there any chance of revoking the I-140 because of underlying non-immigrant?
No, I cannot.
Okay.
No, that's not a reason, because I told you the same job could qualify for L1B and L1A both. So does your job qualify? I don't know, because I don't know your job. Your lawyers can tell you better.
Okay, Rajiv. Yeah, thank you so much.
You're welcome. Good luck. Okay, let's go on to the next one, which is Virginia. Virginia, go ahead. I can hear you.
Namaste, Rajiv. So my question is, if I plan to join past employer, should they file 485 first and then H1B, or vice versa?
I don't think the order is relevant. It can go in any order. They can file 485 first, then H1B. They can file H1B first, then 485. They can file both together. I don't think the order is relevant. Okay.
Okay. And if since, as I said, I applied for B2, so if I am B2 and my past employers filed the H1B, so can I work on the receipt?
No. Good luck.
So one has to be approved.
One has to be maintaining H1B status or approved. Okay.
Oh, okay.
All right.
Got it.
Good luck.
Thank you.
You're welcome. Okay, let's see. The last question today is from Texas. Yeah, Texas, go ahead, please. I can hear you.
Hello, Rajivji. Can you hear me?
I can hear you, ma'am. Yes, hello.
So, Rajiv, this is Amrita, and few days ago I called you about the H1B revocation and the going back to STEM OPT.
Oh,
So
yes.
I just had one more question.
I remember. Yeah, Amrita, go ahead.
Yeah. So I just have one question about one or two questions. Like, for example, my DSO said that they would file for change to F1
but it's most likely to be denied because I don't have the
Acha.
official withdrawal notice from USCIS. But still, they're going ahead.
Amrita, 1 second. Did you open a case with Ombudsman?
Yes. Yeah, I did open a case with Ombudsman, and they told me that my case has been assigned to an agent.
Very good.
And
very good.
Now,
one second.
They would take it from there.
1 second. Did you also say that you want it to be expedited?
Yes, I said.
Very good. Okay, that's excellent. Okay, so you did that. Now, I think it will be accepted, but let's see what they do. Okay. So what is your question? Go ahead.
So my question is, let's just say like after the 60 days, let's say October 1, my status got changed to H1B, which I don't have, like which is invalid, right? Because they said withdrawal petition before October 1.
Right.
So what will happen after the 60 days?
After the 60 days, what will happen? Okay, so your question, I'm not sure what this 60 days is. Are you talking about 60 days grace period on F1 or H1?
H1 grace period of 60 days.
If there is no H1, there is no grace period.
Okay.
Because your withdrawal was sent before October 1st. You never converted to H1.
Oh, okay.
Okay. That's
all right. So my only option here would be like wait until the result comes.
Wait until, and remember what I told you, just follow all those things.
All right.
Okay.
Okay.
Good luck,
Thank
Amrita.
you.
Good luck. Okay, folks, as always, great to see you all, great to talk with you. I'll see you again in 2 weeks. Take care, everyone.